Welcome to Building Your Leader Brand. Today on the show, Bob is speaking with Phil Calendrino.
You imagine if Nike's out there and they're running commercials that say, just do it. And then Adidas is out there and they're running commercials that say, just do it. Well, that creates confusion in the market. And so Nike wants to trademark its slogan as well as its swoosh symbol and as well as its actual name. So in order for something to be trademarked, eligible for a trademark, it has to have a certain level of uniqueness to it.
Hi there and welcome back to Building Your Leader Brand. My name's Bob Gentle and every week I speak to incredible people who share their secrets to building, marketing and monetizing your expertise and the mindset you need for your business to grow and thrive. Don't forget that you can download the Personal Brand Business Roadmap at amplifyme.agency/roadmap or hit the link in the show notes. And if you are new to the show, then while you have whatever device that is in your hand, take a moment, a deep breath, and subscribe. It's not hard, but I don't know what device you're using, so I don't know how to tell you to do that, but it should not be too hard. So this week, we're going to be speaking about danger zone, all the things that can go wrong in your business, and they do go wrong regularly. And to help me on this entertaining journey is Phil Calendrino. Phil, welcome to the show.
Thanks, Bob. Appreciate it. Glad to be here.
Obviously, we can also talk about how to make sure things go as smoothly as possible in your business. I've kind of painted a terrible picture of Phil. You're not Dr. Death, but you literally hold the gates to building a business that's going to succeed and thrive. Phil, rather than me flail, why don't you tell the listener
Sure.
who you are, where you are, and what you do?
Okay. My name is Phil Calendrino. I'm an attorney. I practice in Florida in the United States. Business law, I've been doing it since 1998. It puts me at 26 years roughly, focusing on this. My parents were small business owners. My father was an architect. My mom was a florist. And growing up, I spent time at the breakfast table with listening to them talk about trying to run their business and the difficulties and the struggles that they had. I idolized my uncle, my father's brother. He was an attorney. We came from a small town in Illinois. And I think the thing that moved me to become a lawyer was being at a family dinner at my grandmother's house, and a man came up in the driveway and was talking to my uncle. And she lived in an Italian neighborhood, and it was you got that box of Chianti and the basket wine, and he gave him a bottle and he hugged him. The man was crying. I was probably 6 or 7 years old, and I asked my uncle when he came inside, what was going on? Who was that man? And he explained to me what he did and that he helped this man, and this man was really grateful. And I thought right then and there, I got to be a lawyer. And so that's what I did. And I come from an empathetic background of wanting to help small business owners like my parents and following the footsteps of my uncle and helping people, making a real impact on people's lives. And so I started my career with the intent of doing that right out of law school. And started really focusing on, after probably about 10 years into practice, on some of the things that consistently were going wrong in businesses. And lawyers are really good at cleaning up messes, fixing problems after they crop up. And I thought the real value in the tragedy of the way the industry operates is it doesn't get out in front of problems. So that's what I wanted to focus on, is getting more preventive instead of being focused on crisis management. And started developing systems and processes and paying attention to the why things would go wrong. So I get a litigation case and I would kind of reverse engineer it and say, where was the inflection point? What could this person have done differently to avoid this litigation? And over time, just started to see commonalities in the way that worked and started to figure out ways to address them. And so that's the focus now.
So a lot of small business owners, they kind of avoid the law and lawyers because there's assumptions of expense.
Yeah, fees, right.
And I think having seen things go wrong several times, I mean, you and I have been having conversations, for example, about trademarks. And I guess when we're looking at being proactive with the law, I think people can look at things quite differently. They do look at it as an expense. But when things go wrong and they're forced to look at it, it's much, much more expensive. And I guess if you're speaking to a small business owner, what are the kind of minimum protections people should really be looking at? What are the minimum proactive activities people should be looking at around their business to prevent problems from ever actually arising?
Sure. Budgeting is especially important in small business. There's no unlimited budget for people to spend money on lawyers. And also, the law, the professional law isn't necessarily conducive to being efficient with your time. It sort of puts all the pressure on the lawyer to be as thorough as possible to avoid missing something. The last thing a lawyer wants to do is to be hired to protect a business, and then a problem crops up and it was something that lawyer could have handled in the assignment, but for the expense. So lawyers are always very concerned about, covering themselves to say like, okay, here's the scope of what we're doing and we could go more. And, because there's an infinite number of problems that can arise, and no one can catch all of them, and no system can catch all of them. There's always going to be, especially in the United States, litigation over something or some dispute over something, human nature being what it is, and the complexity and nuances of business being what they are. But that's sort of where I sort of focused on really what is a mechanism for a small business. So how can we change the way, give small businesses a model for thinking through legal issues that they don't have. They're just not given this tool to use. And essentially what it is you think of every relationship, transaction, whatever it wants to be. It could be an investor, a partner or an investor stockholder in your company. It could be an employee. It could be a vendor. It could be just about anybody that you would be involved, a customer, of course, for transactions. And you think about, all right, if that goes wrong, what's my first line of defense? Contract would be the first line of defense. So you would be able to put preventive clauses in that agreement just to limit the disputes and control how disputes, basically to disincentivize people from suing. And then the second line of defense would be insurance, to make sure you have insurance products in place such that if you are sued and it's not an intentional act, because insurance isn't going to cover an intentional act, but your contract doesn't filter it out, your insurance company catches it, they pay for the lawyer, you don't pay for the lawyer, they pay for the claim, you don't pay for the claim. And then the third line of defense would be asset protection of, just keeping your business assets protected and making sure that you're not exposing yourself, especially as the business owner, or valuable business intellectual property or valuable assets or cash or whatever it happens to be, making it available to sue, creating a honeypot, so to speak, for someone to go after. So if you just think about that in summary, it's a contract to filter out claims, or to at least mitigate against what kinds of claims and what amounts can be sought. Insurance to cover those that you can catch in the insurance net. And then keeping the honeypot as empty as you possibly can so that you have leverage to settle that claim early. That's a basic model we want to think of. So for people out there who are thinking, I like to do deals on a handshake. I heard a great quote the other day. It's like, I'll shake your hand after you sign the contract. It's not a good idea to enter into oral agreements or not to cover yourself, just for the simple fact of, we're in multinational transactions or in the United States, multi-state transactions all the time. How about just controlling where that lawsuit, if there is going to be a lawsuit, where it is going to be? You want it on your home turf. You don't have to travel halfway across the country to their home turf to handle a claim, as an example.
So this is something I think a lot of people listening to will relate to. I've got a shiny new client in front of me. They are delighted to be working with me. They've said yes to the money questions. They're ready to go. And I don't want to upset them. I don't want to push a contract across the table and say, hey, before we start walking into the sunset set together, could you please sign here? I think a lot of people have this anxiety of, they've already said yes. If I give them this contract, they're going to be offended. They're going to find something to turn that yes into a no. It's going to be a little barbed wire fence that they're not going to want to climb over. I think I'm interested to hear from you how you can make this contract a positive rather than a potential negative for the customer.
Right. So I always explain this to people is we want to create a contract that doesn't feel heavy. You want it to feel like something they can read and understand, and they're assured. When people enter into a transaction with you, hopefully they intend to perform. If they don't intend to perform to do their part of that deal, why would you want them as a customer? It's just going to be, it's going to take away time, energy, focus on your business. It could end up having you to have to hire a lawyer, all this mess of stuff that happens when when a relationship goes wrong. You don't want that. There's a growth stage in a lot of businesses, and you see it, very early on. People are scrambling, and every customer is important, and they'll do anything for that customer. And you can kind of create a spoiled child syndrome with the customer, where they just expect everything immediately. And we've all had those kinds of clients. And then you get to a certain stage of maturity or success or both, and you learn to say no to those clients, because it is better for you not to have to deal with the problems that brings, and focus on maybe 3, 4, 5, 10 other clients that could fill the void that one problem client is leaving for you. Flipping it around from from the client's perspective, well, if you have a nice contract that looks professional, it does add an air of credibility to your business as well. Even if it's not beneficial to the customer, just the fact that they're expecting a contract to be in place. The better that looks, and the more professionally drafted that looks, the in a weird way, the more confidence that customer has in doing business with you. You are put together. You know what you're doing. You're protecting yourself. They intend to perform. As long as those contract terms aren't too onerous, it can actually be a positive. And especially if you think about now, also the frequency with which we enter into contracts, click to signs and other things. There's some caveats there with how to make those enforceable and not unconscionable contracts that can't be enforced. But if it's done properly, and especially, for instance, with a checkbox, some affirmative action they have to take, like checking the box, I agree, rather than just clicking through. We call those click wrap agreements. Anyway, bringing it back to the point, just of contracts are ubiquitous in our society now. We expect them. We kind of flow right through them. As long, if somebody's really taking the time to read it, it doesn't feel too heavy. They understand it's protecting the person they're engaged in business with. And so you just want to think about that. It's like, people are used to signing contracts, and it's going to be okay. Have the courage to do it.
Yeah. So it really does come down to make sure your contract is essentially doing the right thing, that there's nothing in there to catch the customer out. Beyond that, treat it as a filter mechanism. Because if a customer isn't willing to sign that contract, there are only two reasons. There's something wrong with the contract, or there's something wrong with the customer. And you kind of want to know both of those things. And beyond that, I say this as somebody who admittedly doesn't use contracts, but is aware he needs to change it. Something to celebrate together. This is you both embarking on a journey, and you've both agreed what that journey is, and it's going to be somewhere great. I think that the attitude that you bring to the contract is probably a big part of it.
That is a big part of it. It's how, if you present a contract to someone and you're unsure of it, or you're not confident in it, that's going to show through, and it's going to invite that, perhaps just instinctively as humans, we pick up on those kinds of things. It's going to invite them to start to try to negotiate or ask questions. That's the next phase of it, is what do you do if the person comes back and objects to some of those terms? Well, you want to have a little bit of a script ready to go to explain why it's important and why you need it in there. And then really think about the person that's asking the questions is in control. So you ask a question, and in return, it's like, is that a problem that you don't think you would be able to meet the obligations in this provision? 9 times out of 10, people are like, no, of course I would be able to meet it. It's like, all right, well then it's, a problem, we'll put it in there. Or I want something added in the contract for this. And then you just have to say, the legal expenses associated with customizing our contract for every customer. I'm sure that you can understand you wouldn't want to do that with your customers. We can't do it with our customers. It's the contract we've it's fair. It's as much as our commitment as it is your commitment. Some kind of script that you're going to come up with to handle those kinds of objections. And then if the person still isn't going to sign, maybe it's better that you focus on someone who will.
So another area of protection that's particularly relevant to my audience is their intellectual property. They're typically people operating in the expert space, or consultants, coaches, people like that. They have frameworks they've developed. They have specific methodologies that they like to become known for. And I guess different people have different ways of looking at it, I guess. But as a lawyer looking in from the outside, what are the biggest areas of risk that you see, and what are the most common ways to protect that?
Well, first, I would look at it from a business perspective before I would look at it from a lawyer perspective. And one, is it really something that's worth protecting? Is it so? There's a lot of misconception out there in the business whether you have to be original and unique. And I think we focus on unique selling propositions so much that we lose sight of the forest for the trees. And really, you just have to be better at executing and delivering on an idea more often than you need something that's completely unique. And, if you have something that's absolutely unique and unless it's extraordinary, who really needs it? It's going to be so uncommon that you're going to have to spend a lot of time marketing and promoting. Whereas if, for instance, you sold, I don't know, soft drink sodas, there's tons of competition out there. And yeah, you want to protect your formula, but let's face it, Pepsi could reverse engineer Coke's formula in a heartbeat. They don't do it. They just make theirs taste a little different. And they know that some people are going to like Coke and some people are going to like Pepsi. So I wouldn't. And so in terms of models, and I see it all the time, in content where it's kind of everybody has a unique take on something, and the model is but it's all packaging a lot of the same intellectual property at its core. It's not really proprietary. It's just the wrapper that's put on it or the way it's organized or thought about. And also, if you're going to share it publicly, people are going to copy it anyway, and you can't be out there policing all that. So a lot of it's just good business processes, practices, marketing, all those things that make a business great. Focus on that more so than the paranoia of somebody's going to copy this thing if I let it get out there in the public. That being said, there are things that maybe are internal in your company, and that's where I would look for the greater threat is the people internally who have access to your confidential information. I'm talking about employees primarily, or it could be an independent contractor or even a vendor. And are you protecting it with a non-disclosure agreement or confidentiality agreement? Because that can protect information that doesn't rise to the level of a trade secret. What is a trade secret is a business practice, formula, device, whatever it happens to be, a thing, an intellectual thing that derives independent economic value from not being generally known to the public. That's the legal definition of a trade secret. It's pretty high up there, right? It has to be yours. It has to be unique, has to have value by not being known. As soon as you release your business program out into the world, your model, your framework, it's publicly known. So it's no longer a trade secret. Well, how do you still protect internally? Maybe you're developing some new aspect of that and your employees know it, and somebody leaves and goes to compete against you using your own model. That's kind of the thing you would want to worry about. You protect confidential information, like a tier below trade secret. But because it's a contract, you can protect that information, and they promise not to disclose it or use it. Two aspects of confidentiality agreements, by the way, NDAs. So folks out there, if you're signing an NDA or looking at an NDA, there's two aspects of it that you will not disclose it to others, which everybody kind of understands when they're signing NDA, non-disclosure, confidentiality. Obviously, they're going to keep it secret. And the other part is you won't use it. And that's the more powerful part of it sometimes. So be careful if you're signing one of those things, that you're signing one that's got both halves of that. So, and think about whether you really want to say, not only will I not disclose this to others, but I won't use it myself, because you're kind of inviting an opportunity to be sued. If someone accuses you of using it, even if you haven't, you still have to defend that claim.
Anyway, even if it's quite generic.
Yeah. On the other side of it, you want to use it as much as possible to protect your information. And that's how you do it. Not a trade secret law will protect trade secrets naturally. You can patent it, you can copyright it, you can trademark it. Those are things that you're going to release into the public. That's going to be protections available for you to stop other people from imitating it, creating confusion about source, other things. Those are of some utility. And then intellectual property agreements like an NDA or a confidentiality, they're just the same thing. And then with employees or certain contractors, you can use other restrictive covenants like non-solicitation provisions. We call them restrictive covenants: non-solicitation, non-compete, non-disparagement, things that restrict somebody from taking certain action with respect to that information.
The one area, and I think I agree with you when it comes to processes and practices and frameworks and things like that, the process themselves, once they're out in the wild, they're out in the wild. Where things are maybe a little bit different is the way that we name things. If you want to become known for a specific method and you give that method a name, trademarking is a common approach of protecting that. What is valid to trademark? And what should people think? No, this is a silly idea. You shouldn't bother with trademarking that.
Well, speaking on U.S. trademark law, it's something that no one else has trademarked before, right? So a trademark only will stop somebody from using a name. Trademark is just protect a name or an image, a logo, not really artwork, but just like a particular like logo icon for a brand. Think of the Nike swoosh and the trade name, the name Nike, and maybe a slogan like "Just Do It." I think was their popular one for a long time. So you can protect all of those things with trademarks. And that just stops other people. You imagine if Nike's out there and they're running commercials that say, just do it. And then Adidas is out there and they're running commercials that say, just do it. Well, that creates confusion in the market. And so Nike wants to trademark its slogan as well as its swoosh symbol and as well as its actual name. So in order for something to be trademarked, eligible for a trademark, it has to have a certain level of uniqueness to it. So things like Apple computer are considered, even though the word Apple is common, associating an Apple and a computer is not a common, it wasn't at the time in the 70s when they developed that computer, wasn't a common idea. So it had a level of uniqueness to it that allowed it to be trademarked. If you just named your computer and tried to trademark that, say, no, that's merely descriptive of the item and it's not eligible for a trademark unless it's been used in commerce for at least 5 years. And there's a little process you can go through for some common things. So, but that's the big one, is it can't just be merely descriptive of the services or product itself. It has to have some kind of uniqueness to it. And then if let's say somebody else is using, this is why trademarking is important, especially is if just because you're using it and it's unique does not mean that you can stop other people from using it. You can in your local market if you can show confusion. It's unfair competition in the United States, is the claim we call it. You can stop somebody from doing it if you can prove confusion. Or if you have the trademark, then that's an automatic, just like I have it. This is the description of the goods and services I'm providing. You're using it. I don't have to get into a lot of detail and difficulty in proof, and I can recover my attorney's fees if I prevail, which is important on the American side. I know you're in the UK, and attorney's fees are often awarded to the prevailing party is the English, we'll call the English rule. The American rule is only if the contract or statute allows for it. Well, the trademark statute allows for it. So it's a big incentive to, an advantage in the case for you to be able to recover your fees on top of stopping the activity. So you go through that process, and then you can stop anybody after the date that you filed the application. So if somebody is using it, let's say you have two stores out there that are two restaurants, and they have both independently come up with the same name. And I'm not going to try and invent the name now, but let's just say they're both coming up with the same name. And just for the sake of genericness, I'm going to call it ABC Restaurant. So you've got ABC restaurants starting. One ABC restaurant decides they're going to go trademark that name. The other one has been operating, let's say the day before that, this one that decided to trademark it. Well, ABC that trademarked it is allowed to, it owns that name now. It cannot stop the other ABC from operating because it was out there operating before it filed its application. But it does have the right to open new stores with that name or franchise it or expand out into the world with it. Whereas the other one is kind of in its own little bubble. And then they're subject, by the way, to potentially, if the other ABC has a, I don't know, like a food poisoning case or has a bad reputation, that ABC who has nothing to do with them is going to suffer for it. So it's important. Almost the first thing you want to do when you're just starting the business is to invest in it. And then the other thing you want to think about is what really is a brand or a trade name or a packaged service. So first thing you have to do is kind of search out there. It's like, is anybody else using this? Is this going to be a problem? Because I can't stop them, and I don't want my reputation affected by something they say or do where there's confusion and I don't have a legal recourse because they were first. I can just protect it for the future. So you kind of want to carve out a space that no one else has, reserve that seat through the trademark, and then nobody else gets to sit in that seat. And if you do that, then you really you're now free to invest in that brand, because that really is what a brand is. What was Nike on day one? Nothing. It was
Hmm.
a Greek god or goddess, I don't even know which, but you never associated with a shoe. Apple Computer, you never associated Apple Computer with a great computer in 1978 or whenever it was they came out. Those are the reasons those brands took off, is because they made things that people wanted, and they marketed the heck out of it. So, it's all that money that you invest into that brand, that's the value. It's not the idea of, oh, look at this. I just love this name. And I got, no. It's the money that you invest and the reputation that you develop selling goods or services that make the brand. Don't get caught up. Don't fall in love with the brand before you have it trademarked. It's really, brand is a business function of investment and reputation.
I want to come to the investment and reputation side in a moment, but just a point of clarification. So if let's say I have a brand name that I've been using. I've been using that brand name for 5 years. Somebody comes along and trademarks that brand name today. They can't come to me and say, I want you to stop that thing you've been doing for 5 years.
No, they cannot. They cannot.
Ah,
And you might have, if
that's
you
interesting.
catch it, their mark that they're filing it, you might have an ability to come in and stop them from getting the mark. But you're going to be somewhat limited in that, and if you haven't filed for trademark protection.
Okay.
But you can't be stopped from doing it yourself. They can't make you change what you're doing, as long as what you were doing predates their application date. Not the trademark date. That's an important difference. The application date. It's when they approve a trademark, it goes retroactive to the date of the application. Because you can actually file, by the way, people might not know this, there's what's called an intent to use, ITU, intent to use trademark application, which is, I don't do business yet. I just have this idea. I got this brand idea. I want to protect it before I even start. Then you get 6 months, and you can even extend that another 6 months for a fee of time to show that you're actually now using it in commerce. So you can be very proactive with the trademark.
So that's really useful to know. And I think what I'd like to move on to now is something I've been hearing a lot over the last 5 years, which is my business is my pension. Any small business owner, you'll have heard this a million times, I'm quite sure. And I'm interested to understand from you as a lawyer who helps people buy and sell businesses on a fairly regular basis, what value does proper protection add to a business? And the reason that, to qualify this question, I can only assume that if your customer relationships are protected, if your vendor relationships are protected, and if your products and services are properly protected, that must have a knock-on effect on the inherent legal and commercial value of the business. Am I reading that correctly?
Sure. I'm going to give you a crude example, and just think about buying a used car. Two cars look relatively the same. You can think of it in the context of buying a business as these are in the same industry. One has meticulous service records and one has nothing, right? Or very little, maybe a spotty oil change receipt here or there. Which one? They're both the same mileage. They both look the same. They're both the same color. They both have the same options. They're both the same price. Which one are you going to buy?
Yeah, absolutely.
Right. So it's also, and why is it? Well, when you buy a business as well, you can buy the assets or you can buy the stock, the shares. And an LLC, limited liability company, is a form of business enterprise here in the States that's very popular and came out in the 80s. How well it has membership units. So when I say stock, it really applies to all these different entities. All right. So if you can buy the stock in an equity in the company, buy the company as a whole itself, or you can just buy its assets, take all its assets out. You usually want to just buy the assets because you don't buy the liabilities, like pending lawsuits that you didn't know about. The lawsuit that somebody's about to file and even the business owner didn't know about, right? So it doesn't come up in a due diligence search of like making sure these assets are good, making sure there's no known basis for a lawsuit. There was no threat, no idea at all that this major company killing lawsuit was going to be out there. Well, that's why you want to buy the assets. But also then the trade-off for that is you may not buy the ongoing transactions, the contracts, they don't carry forward unless you assign them. And so there's all kinds of reasons why we might choose one or the other over the other. And then you do due diligence to make sure that those assets are what you think they are, And then the closing part of the transaction is to acquire title to it. And if there's financing for it, you do the financing for it. Well, if you're investing all that time in that process, one of the things that people look for in due diligence, especially if they have professionals like CPAs and lawyers, accountants and lawyers looking at the business, helping them decide if it's valuable, contracts that prevent potential disputes and limit damages make the business safer to buy. It's almost like buying a car with a warranty in a weird way.
Yeah.
Service records and even a short-term warranty, you're gonna be a lot more assured, and that's just worth more so than a company that doesn't have those protections. Who wants to buy a company that's coming with potential litigation?
Well, yeah, I mean, it's just lots of black holes. And yeah, confidence is everything when you're looking at buying a business.
Yeah. Also, just think about it in terms of on the employee side. If I own a business or I'm looking at buying a business and one company has non-solicitation agreements with its sales staff and the other one doesn't, well, any one of those sales staff employees could grab the customer list and go start a competing enterprise. So you need certain kinds of protections to prevent other people from harming the business, other kinds of protections to avoid potential liability, to essentially think you're buying what you're buying. There's multiple facets to it.
So my last question, I think, is acknowledging that our audience today is pretty international. I think there's a lot of myths around the law and transnational immunity, I'm almost going to call it. What are the realities and what are the myths around that? So to qualify that, for example, I'm not in the US, and I think it would be very naive, but it's also probably a very common assumption that I can't be sued, for example, by a client or a vendor or a company in the US. And conversely, the American legal system isn't necessarily accessible for me if I decided I needed to find redress somehow. What are the realities around that?
Yeah, well, you can always be sued on your home turf, right? Somebody that's going to hire, in America, that's going to hire a lawyer in the UK to sue a UK company is going to sue the UK company. And the real question then, sort of that feeling of insulation might come from the fact of like, well, if somebody sued in the United States for an international transaction, how could they get that? And I just didn't show up and they got a judgment against me. How could I get that judgment? How could they get that judgment over here in whatever country I happen to be in and make it enforceable so that it has the same effect as if they had sued me here? That's usually where that analysis comes from. And there's something called the Hague Convention, set of international treaties, Hague in the Netherlands. The Hague Convention on recognition of foreign judicial judgments, something like that. And if there's a number of countries that are members of this treaty, and they will recognize that foreign judgment. Now, there's a process that has to be go through. The person has to be sued in accordance with Hague Conventions on international service abroad. And but as long as those procedures are followed, by the way, some of those procedures allow for service by mail in some countries. So you might just get a letter in the post, and that's how you get served with a lawsuit, as opposed to what we normally have here in the United States is a processor actually hands you the subpoena and says, you've been served, that's a complaint in a court case. And, then you know what you're getting. Well, who reads, you might thought something was junk mail and have tossed it accidentally. Or could have just gotten lost in the mail and not realized, so there's a little bit of proof of service stuff that goes on with that. Let's assume they cross all those hurdles. Well, now they got that judgment. Your country is a member country. There's most of the Western world are going to be member countries to this treaty. And now that judgment becomes enforceable. So now we get back to that where we very first started. We've come full circle, the contract, right? If there is a contract between you, the contract can dictate which country's laws are going to apply. You're in Scotland, right?
Yeah.
Is Scotland law going to apply? Or if we have a transaction, is Florida law and U.S. federal law going to apply? It depends on what we agree in our contract. So it could be an important distinction. One of those little tiny, seemingly boilerplate fine print kind of provisions doesn't really matter. Don't really think about it. Makes a big difference. So does the venue clause, which says if we have a dispute between us, it's exclusively, and the exclusively part's the important part, exclusively going to be in a UK court in this jurisdiction, in this venue, this city, versus mine, which would say state of Florida in the United States, the federal and state courts in the state of Florida. Or we could agree arbitration, which is like a private court system. And there's also like international Incoterms for shipment of goods, like international, so the people can pick their law as long as the law has some relation to the transaction. They can pick their venue and forum as long as those have a relation to the venue, and the courts are going to allow for that. You follow that procedure, you get that judgment in that jurisdiction per the agreement, and you, through that treaty, get it enforced in the other person's home country.
So I think this is really useful. I mean, listening to that, the moral of the story is there is no real insulation. And I think you need to take the legal side of your business seriously wherever you are. That I think when we're starting our businesses, we do so kind of shooting from the hip a lot of the time. But there comes a point where you have to put your big boy pants on and just make sure you've
It's not that daunting. It isn't that daunting. It doesn't have to be. Cleaning up messes is expensive.
Yeah.
But putting these structures in place is not that expensive. A note on AI or internet forms a lot of times are not going to have these preventive provisions. They're not going to be, I can't tell you how many times I get a contract and it has a venue. We just talked about venue clause. It has a venue clause and a choice of law clause in it. And it's got brackets and it's like, enter the jurisdiction here. And I see that enter the jurisdiction here in brackets. And it's like, they didn't pick, they just downloaded some form and didn't know what they were doing, copied it from somewhere else who didn't know what they were doing. And it's really important that you understand. You don't, I would never advise anybody not to have a lawyer, because a lawyer is going to really be a lawyer with experience in this area is going to be well versed in knowing how to pick the right mix of provisions, because there's no such thing as boilerplate or standard, fine print terms. It changes from client to client that I service. In some circumstances, we want attorneys to be recoverable. In other circumstances, we don't want them recoverable. And we may mix and match in different provisions, different kinds of contracts. So it's a very nuanced decision-making process. You can learn it yourself. It takes a lot to learn it, and you might make a mistake or two. But whatever you do, don't just let AI decide what your provisions are going to be, because they're going to be seemingly well written. In fact, it does a great job at writing provisions if you tell it what kind of provision you want to write and what nuance, what flavor of the ice cream you want it to make for you. But if you just ask it for ice cream, it's not going to know. And you're going to get the wrong flavor.
I think this is something I tell people quite often. AI is a great tool for experts because it allows experts to be more efficient and cover more ground more quickly. It doesn't allow you to become an effective expert in something you know nothing about.
I think every day I use AI. I use AI every single day. It's been a great time saver and efficiency. I never let it start. I only let it edit my own work. And I usually will spend, so for instance, something that might take me a day to write, I can usually write in about half the time with it, but I'm still spending maybe 4 hours back and forth with AI to get it tweaked just right. But it just takes the mundane part of like the best way to phrase, what word should go first, where should the comma go? Even then it makes mistakes. I have to fix it. By the way, if you ever ask it for what a statement on the law, it is going to hallucinate. Almost invariably, it's going to completely make up a case. It's gotten better at it, but it just always, you can't help it. So I tell people it's like having a friend who is a genius and a pathological liar. And so you can't, it might be right. It may be profoundly right, but you can't trust it.
So I want to move into the next part of the interview now, the three amplifiers. I'm calling them that now, Phil, by the way. Have you got 3 things for us?
Sure. I think it's along the lines of what we talked. It's protect your business with contracts, insurance, asset protection. Focus on protecting your brand and intellectual property through the use of trademarks, the public laws that are available, trademark internationally, through the Paris Convention, trademark can apply globally. So you want to protect your trade. You can get your trademarks filed keep your confidential information confidential from being released by insiders in your organization through the use of non-disclosure and confidentiality agreements and restrictive covenants, like if they're available in your jurisdiction, non-competes, non-solicitation, non-disparagement's a big one we hadn't talked about, but online reputation. You don't want your employees going online and who are disgruntled and blasting you without any recourse to get a court order to, gag them from doing that. Customers, you can't do that caveat so much, at least not in the United States. There's laws that allow for honest and open reviews. Honest and open review doesn't mean they call you a fraudster. It means that they say they don't like your product or service. And so use those restrictive covenants, and then really just focus on I would say just in a focus on all your processes and procedures in your business as you're developing those. Think about the legal. Think about what you can do to how that relationship, whatever it is, might go wrong with the customer or vendor, and what you can do to protect yourself.
I think that's really, really good advice. And honestly, I've had a really useful time with you today. When do you get to spend this much time and ask this many questions of an attorney without getting an invoice? This is awesome.
Oh, I thought I was sending you an invoice for this. Nervous.
What does an ideal client look like for you?
An ideal client for me is a business owner it could be a startup business owner, or it could be an experienced business owner. I look for business owners who are receptive to the idea of preventing problems, as opposed to just want to kind of blindly go. And so it's an attitude. Do they have that critical thinking structure? Are they a disciplined business owner, or are they just shooting from the hip everywhere in every direction? And if they are shooting from the hip, are they someone that wants help? And so it's somebody who wants help and can make decisions that are like, okay, yes, I need to invest in this in my business because I understand the value of protecting it. And that's usually, it can be anywhere from a startup, to somebody maybe with about 10 to maybe on the higher side, $20 million annual revenue. Basically someone that doesn't have in-house counsel and is still actively involved in running the business, or if it's a real estate investor, and because that's a form of business, you're renting these properties out. And typically we're dealing with companies that have a small group. We call them closely held entities, a small group of owners. It's usually their family business, one or two owners, a husband and wife maybe, or a small group of people, which you can kind of all together blob together and call it like a closely held or family type business. That's who we look for. And then obviously we'll want to add value. That's our big thing, is we want to make sure that we can add value and right size our services to what they need. So most everybody has holes in their system. And we can, even if they've had a lawyer in the past, there's things that contract might be missing that we can improve on, won't cost very much money. Or basically we can run a basic set of protections for an entity and kind of on a program systematic way, so it's not so expensive for them. And by the way, we don't charge hourly fees. So I was just kidding about the invoice. We only charge flat fees.
And obviously you practice in Florida.
Yes.
Are there any exceptions to that? Are there any situations where an international or broader than Florida makes sense for you?
No, we're not allowed to take clients who don't. Yeah, they can be international. It has to have some connection to the state of Florida. Either the transaction is occurring here, they have an office here, they're moving here, they're already here, whatever happens to be their residence here. The dispute or the transaction has to involve the state somehow for me to practice. Lawyers in the U.S. are bound to one state, the state that they're barred in. They've passed the bar, they're licensed. There's some reciprocity. Some lawyers can do multiple states. Florida is kind of isolationist. It doesn't let anybody in, so other states won't recognize it. So we're sort of stuck with Florida. But that's a pretty big playground for us, so we're okay.
And if people want to go deeper with you, where can they find out more about you?
I would say the best way is just go to Forward Law Firm, FORWARD, lawfirm.com. And you can find out anything about us there. There's links to talk to us. We don't charge for consultations. You can find me on LinkedIn as well, either the firm page or me personally. I don't check those messages at all. The best way to get a hold of me, if you're really trying to get a hold of me, is just go to the website and click the button that allows you to book a free consultation.
Awesome. I'll put links to all of that in the show notes. Phil, this has been a lot of fun. I really enjoyed it. Thank you very much for your time.
Thank you. I've enjoyed it as well. Take care.
And that does bring us to the end of another episode. Thanks for listening. And if you did enjoy the show, I would invite you to leave a 5-star review. You heard me right. 5-star review wherever you listen to podcasts. And if you did enjoy the show, you will love the Personal Brand Business Roadmap. It's everything you need to start, scale, or fix your expert business. Visit the link in the show notes or go to amplifyme.agency/roadmap. Thanks for listening. And again, Phil, thank you very much for your time.
My pleasure. Thank you.